The Supreme Court has agreed to take up the provision of Obamacare which mandates private employers who are covered by Obamacare to include contraceptive coverage for women. Now, the argument against it is that somehow contraception morally offends some people. I will try not to be overly disparaging in dismissing that argument. I get that some people feel that way, but this is healthcare. And the fact is, I think that ultimately, so many of us believe that if you're going to provide health care for your employees, you don't get to pick and choose what kind of health care they get. If they want to use that for contraceptive coverage, and contraceptive coverage sort of helps us all, makes the country better, stronger, more practical, more responsible, and gives women choice to run their lives the way they see fit, which seems like a pretty good idea, I fail to see what could possibly be wrong with that. But there are some who do. And the Supreme Court has agreed to hear two cases. One from a craft chain store called the Hobby Lobby. The Hobby Lobby has actually won a case with the 10th Circuit. Now, the 10th Circuit Court of Appeals is in like Utah and Kansas and most of Oklahoma, Colorado, Wyoming. So that part of the country sort of agreed with the Hobby Lobby that they don't have to do that. But, however, the Third Circuit Court of Appeals defeated a case brought by the Conestoga Wood Specialties. I don't know what they are either. It sounds like the Conestoga Wood Specialties might make things that the Hobby Lobby would sell. But I don't know. Anyway, the Conestoga Wood Specialties, they lost their case with the Third Circuit. The Third Circuit is Delaware, New Jersey, and a lot of Pennsylvania. So a circuit sort of in the Mountain West, if you will, said that Obamacare can't cover that. And the Third Circuit said that, yes, it can. Obviously, that's one of the most basic times for the Supreme Court to get involved when two different federal circuits rule differently. The Supreme Court has to come in and settle that case, and they have said today that they will take up the case. A quick statistic, and we have a graphic for you on this. This would be graphic 12. This was taken from a Washington Post story today, and it just shows you there the percentage of all Americans, and this study was broken down into into more specifically by faith. But just to give you a look of how all Americans feel about whether these types of places should provide contraceptive coverage in their employee health plans. Let me see the graphic again real quick there. I'm going to read it to you. Churches and other places of worship, that number's 42%. We don't have the number against for all of those, but it was right around that same number. But it's safe to say that a lot of Americans are comfortable with churches and other places of worship not covering that stuff. We get that. But then as soon as you move to religiously affiliated social service agencies, the number climbs. 52% think they should cover. Privately owned small businesses, that would be like the Hobby Lobby and Conestoga Wood Specialties, 53% saying that they should cover people. The opposition for those numbers was in the low 40s. They were both ahead by about 10%. Religiously affiliated colleges, a similar number, 54% should cover. Religiously affiliated hospitals, 57%. I don't quite see what the difference is there because we're talking about the employees. We're not talking about the treatment of the patients. But anyway, the numbers increase. And then finally, publicly held corporations by about 30 points, about 62 to 32, that Americans believe that contraceptive rights should be covered. So I'm pretty sure the Supreme Court doesn't look at those numbers, nor should they look at those numbers, but it will be interesting to see how the Supreme Court rules. Again, having to settle a difference between the Third Circuit and the 10th Circuit. It surprised nearly every judicial watcher there was when John Roberts decided in favor of the legality, the constitutionality of Obamacare in that historic 5-4 decision that approved the law. Now we'll see where Roberts stands on this issue.